specialized knowledge professionals to the U.S. without undergoing the often lengthy processing periods that regular L petitions take. This simplifies the process of approving and admitting additional individual L1A and L1B workers and can result in significant savings of both filing fees and time. Persons transferring from one qualifying organization to another can bypass the USCIS Regional Service Center and proceed directly to the appropriate U.S. Embassy or consulate abroad to apply for their L1 visas. Let's look at what organizations qualify for the Blanket L petition. To qualify for an approval of a Blanket L petition, the petitioner must meet the following criteria. 1. Each entity included in the Blanket petition must be engaged in commercial trade or services. 2. The petitioner must have a U.S. office that has been doing business for at least 1 year. And 3. The petitioner must have 3 or more domestic and foreign branches, subsidiaries, or affiliates, and combined they must meet one of the following requirements. They have to have obtained approvals for at least 10 L visa managers, executives, or specialized knowledge professionals in the last 12 months, or they have to have achieved a combined annual sales of at least $25 million, or they must employ a U.S. workforce of at least 1,000 employees. The Blanket petition versus regular L petition. What are some of the strategic considerations? Let's look at processing times. A Blanket L petition takes a long time to prepare and submit to the USCIS, and it requires extensive documentation. But once it's approved, it provides that multinational organization with a very potent tool to quickly transfer executives, managers, and specialized knowledge professionals to the U.S. A regular individual L1 petition may take 6 to 8 weeks or more for processing at the USCIS Service Center. However, under an approved Blanket L petition, an intending intra-company transferee may enter the U.S. within about 1 week after submitting their visa application and their Form I-129S at the consulate. Let's look at some of the substantive differences. A regular individual L petition requires every petition to establish both that the individual transferee is eligible for transfer and that the necessary corporate relationship exists. However, the Blanket L program assumes that the qualifying organization criteria have been proven and requires only proof of the transferee's individual eligibility for the L1 visa. Transfers within the U.S. A Blanket L beneficiary may transfer to any other U.S. organization that is listed on the approved Blanket petition during his or her stay in L1's visa status. They can do this without referral to the USCIS if the alien's duties will remain virtually the same at the new organization as at the old organization. There's a reduced filing fee expenses. The USCIS filing fee for premium processing and regular processing for every individual L1 petition is $1,320 or $320 respectively. However, after the initial L Blanket petition is approved, there are no USCIS filing fees for the Blanket L application before the consulate until the petitioner elects to file for a Blanket L extension. Let's look at the Blanket L process. The procedure is fairly simple. The initial Blanket L petition is filed with the USCIS Regional Service Center that has jurisdiction over the petitioner's main U.S. office. No specific individual transferee need to be named in the petition. The USCIS restricts its decision only to verify the basic criteria concerning the qualifying relationship of the named entities, the commercial nature of their business activities, and their qualifications. The decision whether a specific alien qualifies for L consideration or L classification is made by a consular officer who reviews the alien's visa application, or by a USCIS Service Center if the alien beneficiary is visa exempt or applying for a change of status in the U.S. Let's look at documentation. The basic petition forms are the same as those used for individual L1 petitions. However, the manner of completing the forms is somewhat different. A supplemental list of all domestic and foreign parent, branch, subsidiary, and affiliate organizations must be included. Broadly, the document document must include the following supporting documentation. 1. Proof of each domestic or foreign branch or office, their articles of incorporation, LLC registration, registration as a branch office or other documentation. 2. Proof of relationship between the companies. 3. Proof that each office is actually doing business. 4. Proof that the U.S. office has been doing business for over 1 year. This will include tax returns, financial statements, sales brochures, product orders, any of that type of documentation. 5, you have to prove at least 10 transfers, the approval notices for 10 Ls approved in the past 12 months, or those combined annual sales of at least $25 million, or the employment of a U.S. workforce of at least 1,000 employees. Types of evidence suffice to establish corporate relationships for L1 petitions also generally suffice for blanket L petitions. The annual sales and or total number of U.S. employees can be demonstrated through an annual report, federal securities filings, audited financial statements, payroll tax records, or a recognized independent authority. The number of L1 individual visa holders approved during the previous year can be established very easily through copies of the individual approval notices, the USCIS Form I-797. The duration of the L1 blanket. The initial validity of an approved L1 blanket petition is 3 years. The petitioner is then required to file for an indefinite extension of the blanket petition. If the petitioner fails to apply for that extension, then the service denies the extension, the petitioner may not file for a new blanket L petition for 3 years. However, once that petition is in place, adding a new company to the blanket petition is relatively easy. Additional organizations may be added to the blanket petition by the filing of an amended blanket petition. When you are admitted under the blanket petition, you are applying only at the consulates. Once the service has approved the blanket L petition, the organizations listed on the petition can begin to use the petition to move personnel to the U.S. This is accomplished through the submission of the USCIS Form I-129S. That's the Certificate of Eligibility for Intra-Company Transferee under a blanket petition. Submit that along with all the supporting documentation. L1 non-immigrants are required to have been employed continuously by a parent, subsidiary, or other affiliated organization of the petitioning company for 1 year in the 3 years preceding admission to the U.S. For a brief period, this requirement was reduced to only 6 months. But legislation was overturned by the L1 Visa Reform Act of 2004. This reintroduced the requirement of a 1-year employment abroad for L1s coming under the blanket petitions. Documents supporting the visa application to consulate. In essence, the employee must provide evidence that he or she has been employed abroad in a managerial, executive capacity, or as a specialized knowledge professional. Beneficiaries who have specialized knowledge but are not professionals, i.e. that their position does not require a bachelor's degree or they don't have that bachelor's degree, are not eligible for the blanket program. And then his or her employment in the U.S., those people applying under the blanket L, their employment in the U.S. will be managerial or executive capacity or as a professional with specialized knowledge. Generally, the blanket L visa applications at U.S. consulates and embassies are accompanied by the following supporting documents. Corporate documentation of the transferring and receiving listed blanket entities. Letters of support from the U.S. petitioner. These letters must detail the prospective transferees' qualifications and the proposed job description in the U.S. Have to submit required copies of degrees, transcripts, for specialized knowledge professionals, and you have to submit organizational charts for executives, managers, or functional managers. The individual has to submit a resume. You have to have a letter of employment from the overseas entity detailing the proposed transferee's previous employment. That employment must have been in specialized knowledge, managerial, or executive status, and it has to have been for a period of more than 1 year. You have to submit foreign income tax forms or wage statements showing the proposed blanket transferees employment with that foreign entity for at least 1 year. And the person has to have a valid passport, which is valid for 6 months longer than their proposed stay in the United States. Let's look at admission. An L1 non-immigrant initially seeking admission under a blanket petition may be admitted for a period of up to 3 years, even though the initial validity of the blanket petition may expire before the end of the 3-year period. Subsequent applications for admission. An L1 alien may not be admitted for a period of time that exceeds the statutory limitations on all L1 stays in the U.S. An L1 alien who has spent either 7 years in the U.S. in a managerial or executive capacity, or 5 years in specialized knowledge capacity, may not be readmitted to the U.S. as an L1 unless that person has resided and been physically present outside the U.S. for the immediate previous year, except for those brief visits for business or pleasure. Let's look at how an L1 will change employers, what kind of petitions are required, what situations that can happen. There are 2 types of change of employer situations that a blanket L alien may incur. Those that require no notification to the USCIS, and those that do require referral to the USCIS. The CIS's regulations state that a blanket L may be reassigned to any organization listed in the approved blanket petition without referral to the service during his or her authorized stay if the alien will be performing virtually the same job duties. However, if the alien will be performing different job duties, or they are going to be transferred to a related company that's not included in the blanket L approval, then filing of a new Form I-129S may be required. Reviewability of the denials. The blanket L program has at least one strategic disadvantage compared to the regular L program. It exposes its principals to the peril of non-reviewable consular discretionary authority. Unlike participants in the regular individual L transferee program, whose individual petitions must be filed at USCIS service centers, the vast majority of transferees under the blanket L program file visa applications at consulates and embassies abroad. While a denial of a regular L petition at a USCIS service center may be appealed, consular denials of blanket L visa applications are not reviewable. However, a blanket L application that has been denied can still be filed as a regular L application. Let's look at some other alternatives. An L1 blanket does not require that all transferees to the U.S. use this mechanism. Individual L1 petitions, or any other types of work visa petitions, may still be submitted by members of the family of organizations. Alright, let's look at conclusions here. The L1 blanket approval is not just for mega multinational operations. The essential legal requirements to qualify for a blanket approval are actually relatively modest. A blanket approval can ultimately expedite transfer of managers, executives, and specialized knowledge professionals by avoiding the need to file separate individual petitions and establishing the qualifying relationship between the U.S. and foreign entities each time the corporation seeks to transfer an employee to the U.S. Visa Pro provides you with the expert guidance necessary to be successful in your L1 applications. Contact Visa Pro if you have any questions regarding the L1 visa or need help in filing. Our experienced immigration attorneys are always there to assist you.